Hey, barbecue fans, Ian from the Iron Pig here. Hey, just sending out a quick update. What's happening with the Iron Pig and our motion for declaratory relief on 6 other health-related statutes. Now, I always hate saying that this is a lawsuit against the health department because it really isn't against the health department. It's laws that were passed by the legislature back in the 70s that the health department during 2020 through 2022 used during the pandemic. Now, 2 of these statutes, the Iron Pig has already had rendered unconstitutional by the 46th Circuit Court here in Otsego County. Those are MCL 333.2253 and .2453. So one's a state and one's the local version, and those basically say that the state or local health director has the power to, quote, limit the gathering of people for any purpose and may establish procedures. Judge Hunter here in Otsego County ruled those unconstitutional and basically struck those from Michigan's Constitution. In doing so, with the local declaratory relief that we were seeking, he did not address 333.2251, 2451, 2455, 5201, and 5203. So there's 5 additional statutes, and our vesting clause argument, which is very simple, says that the Michigan Constitution explicitly says that one branch cannot divest and give its power to another branch. And that's precisely what happened during the pandemic. Is the legislature basically gave its law writing and lawmaking ability over to the health department. At first, it gave it to the governor. That was struck down by the Supreme Court in October of 2020. Then came the health department. That was struck down by Judge Hunter here in Otsego County. The local version also struck down. So we are challenging these additional 5 statutes. And really, I kind of kept my mouth shut on that interview that Gretchen Whitmer gave with Caleb Hammer a week or 2 ago now, in which she admits that she was given, or they had, very bad or limited information. This is complete bullshit. I cannot believe that she actually even had the gall to say that. This is precisely why I am still battling in court, because years later they just get to say, well, you know, we had bad information, or hindsight is 2020. I'm done with that shit. Here's why we're still battling this 5 years after the fact, because each of these statutes has meandering language in it, just like the other ones did. May limit the gathering of people for any purpose and establish procedures. That gave us face masks, sign-in sheets, stickers on the floor, all that stupid shit. You know, 12 people in your house for Thanksgiving, all this stuff. You know, the inside can't be inside, but you can do the inside outside, right? That was the whole joke during Caleb Hammer's interview, in which she said, well, we were working with limited or bad information. Horseshit. You guys knew exactly what you were doing. You stood there week after week. And in fact, today is the day that they extended us another 12 days of lockdown 5 years ago because of this now bad or little information. It's garbage. This is why we're still on this mission. So when you start looking at these statutes, which again, there's a lot of them and you don't have to get nerdy, but I'm going to tell you, 2 of these statutes, 2251 and 2451, they try to explain what an imminent danger is. They don't go on to say what it is. They just say that it's an imminent danger. Let me pull that statute up real quick for you guys to see. It's just, it's ridiculous. The local health officer may prohibit the gathering. That's 2453. 2451. Here we go. Imminent danger as a condition or practice which could reasonably be expected to cause death, disease, or serious physical harm immediately, or before the imminence of the danger can be eliminated. The problem there is reasonably. I always say this. The legislature passed a law for the speed limit on I-75 in northern Michigan. It's 75. It doesn't say reasonable speed. That means something different to everyone. We need more specificity in these laws. So 2251 and 2451, they're the same law. One gives state, one gives local health director that power. Imminent danger by what the health officer reasonably believes. Again, this law was specifically used against me and the Iron Pig because the health officer at the state and the local level reasonably believed that we were an imminent threat or danger because we merely were not complying with the law. Now, the health department in proceedings, in hearings, had to admit into the record that there was never COVID-19 at the Iron Pig. There was never even a mere contact trace that they could provide the court with. So again, these are laws that they're going out ahead of time and punishing people for something that was never even done. We never were an imminent threat. Restaurants, by and large, were never the imminent threat or danger that they claimed that we were. So you see where this is going? The meandering language is all over the place. So let's move on to 2455. In this one, confers broad sweeping authority to a lone health director to issue an order to, quote, avoid, correct, or remove at the owner's expense a building or condition which violates health laws which the local officer or director has deemed. Again, this is what they used against me to say that the actual condition never was there. The only condition that was on my premises was the mere fact that I was not complying with a now unconstitutional law. Again, they could not provide any single case of COVID-19 or a single contact trace as admitted by the health department. Again, you see where this is going? A condition. Let's move on. 5201, 5203. Reasonably believes. Again, here's that word, reasonable. Confers broad sweeping authority to a lone local health director defining a carrier as an individual who the department reasonably believes to harbor an infection, whether or not there is present discernible disease. Again, they use this to shut down my business. There was never an imminent threat. There was never a condition on the premises. 5203 provides that upon determination by a local health officer, again, their only determination was that I was not in compliance with a state now unconstitutional law. The local health officer shall issue a warning or notice to the individual requiring the individual to cooperate. See how they start to layer these things together? The first one was built on nonsense. There was no condition on the premises. Then we move to the reasonably believes that I am a danger or there's a condition. Then they get to issue an order closing my business, taking my liquor license, taking my food license, all of these things. The local health officer with the authority to require an individual to cooperate if the finding of the health officer reasonably believes that the individual has an infection without further notice. Again, no infection ever happened at Iron Pig. This is why it pisses me off so bad that our fucking governor sat there and said, well, we were working with really bad or limited information. No, you weren't. I'm coming for your ass, all of you. The health department, the governor, Dana Nessel, every single person that was complicit in all this bullshit, including the legislature. I'm sorry, but you guys did nothing. I got an amicus brief on this thing, and that's it. So guess what? A lone business owner is the last man standing. I'm coming to Lansing on Wednesday, December 10th at 11 a.m. in front of 3 judges in the Court of Appeals. This is the next level of taking the fight where it needs to be taken because our legislators don't have the gumption to do it. Us little people, small business owners, take the brunt of all of this. Now we're going to finish it. I'll be in Lansing on Wednesday, 11 a.m., Court of Appeals. Come and join us. We'll see what happens. I love you guys. Thanks for staying with us.